Major breaking news out of California. The United States Court of Appeals for the Ninth Circuit has just ruled in a 3-0 unanimous decision that California's rule or law that says you can only buy one gun a month in that state is unconstitutional under the Second Amendment. A big win for freedom, a big win for the Second Amendment, and a big loss for Gavin Newsom, who's getting used to big losses just recently. Let's break it down. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so the U.S. Court of Appeals out there in San Francisco, the Ninth Circuit, believe it or not, in a 3-0 decision, in the case of Gundies versus Bonta, a Second Amendment challenge to California's law, dealing with a ban on buying more than one gun a month, has been found to be unconstitutional. Now, just to jog your memory, the U.S. District Court out there in California, who heard this case of Gundies versus Bonta, had previously found that California's one gun a month, and that's all you could buy, was unconstitutional under the Second Amendment. There was an oral argument in this case in front of 3 judges. And that permanent injunction that was entered against the state of California, preventing them from enforcing that law, that permanent injunction that was enforced, or I should say entered in originally by the federal district court, was actually reaffirmed quickly by the 3-judge panel in this case from the Ninth Circuit. But we have now received the opinion that basically lays out why this 3-judge panel had previously decided to allow the permanent injunction entered by the district court to remain in effect and to go into effect, preventing California from enforcing this law. In short, the 3-judge panel essentially applied Bruin and said that they're going to affirm the district court's summary judgment ruling in favor of the Second Amendment plaintiffs, which held that California's one gun a month law, which prohibits most people from buying more than one firearm in a given month in a 30-day window, 30-day period, that this facially violated the Second Amendment. The panel applied NYSERPA versus Bruin, the methodology, which, as you know, the Bruin methodology is really nothing more than the Heller methodology from the Supreme Court's decision in DC versus Heller back in 2008. Basically, the court here said that textually, this is actually quite interesting, folks. They say that textually, the right of the people to keep and bear arms includes ancillary rights. I like to call them concomitant rights, but it's perfectly fine to call them ancillary rights. These are rights that are so intertwined with the right to keep and bear arms that even if they're not expressly mentioned in the text of the Second Amendment, they are indeed covered. An example of this, of course, is that famous decision by the United States Court of Appeals for the Seventh Circuit out of Chicago in the Ezell versus Chicago case. If you're not following Miss Ezell on X, you should do so. Big proponent of the Second Amendment and gave rise to the most important precedent on the right to train with your firearm in American history to date. We'll see what the Supreme Court says. That'll be even bigger, but we're not there yet. So anyway, thanks to the Ezell case out of Chicago, the Ninth Circuit cited to that case, pointing out the right to train with a firearm is not expressly mentioned in the text of the Second Amendment. But obviously the right to train with a firearm is part of the textual right to keep and bear arms because it's a concomitant right or an ancillary right. For example, the ability to acquire a gun is another example. And that's exactly what they talked about here. And that's why they cited to the right to train, which is not expressly mentioned in the text of the Constitution, but is protected by the Second Amendment. And they said by extension, by analogy, the right to acquire a firearm is a necessary prerequisite to the right to keep, which means to possess, and the right to bear, which means to carry. Because the right to keep and bear arms requires you to acquire it first and foremost. That means that the conduct or the activity of a Second Amendment plaintiff or a Second Amendment rights claimant seeking to acquire a firearm, to the extent that there is a law that infringes upon that, interferes with it, hinders it, that obviously implicates the text of the Second Amendment. And here California is basically saying that you could only buy one gun a month. Well, this obviously implicates your ability to keep and bear arms, because you can't keep and bear arms, you cannot buy it. So California advanced this sort of spurious argument that says that you only have the right to keep and bear one gun, one arm. Now, this is just borderline frivolous, in my opinion, and the court basically said there's no merit to this argument. Obviously, at the most basic level, to understand that we have the right to acquire multiple guns, you only need to read the text of the Second Amendment. It says the right of the people to keep and bear arms. Arms, that's plural, more than one, shall not be infringed. And that's basically what the court said. Here's what the Ninth Circuit said to dismiss that argument out of hand by California that you only have the right to acquire a gun, not multiple guns. California suggests that the Second Amendment only guarantees a right to possess a single firearm, and that plaintiffs' rights have not been infringed because they already possess at least one firearm. California is wrong. The Second Amendment protects the right of the people to keep and bear arms, plural, side to the Second Amendment. This guarantees the individual right to possess and carry weapons, plural, citing to Heller. And not only is arms stated in the plural, but this term refers to more than just guns. It includes other weapons and instruments used for self-defense. California's interpretation would mean that a Second Amendment only protects possession of a single weapon of any kind. There is no basis for interpreting the constitutional text in that way. Of course, it's beyond stupid, right? If you think about it, I have the right to free speech. I have the right to buy books. I have the right to write books. I have the right to write op-eds or speak. So am I limited by the number of times I can petition the government under the First Amendment? Am I limited in the number of books I'm able to buy? What if I own more books, which I'm capable of even reading in a lifetime? Can the government at that point tell me I can't buy any more books? What if I'd like to go to church every day? Can they say you can only go to church once a week or once a month or once every 6 months, whatever it is? What if they say I can only do one YouTube video a month? Wouldn't that interfere with my First Amendment right to free speech, the right to the free press? I would say so. And there's pretty clear that the three-judge panel agreed entirely with what I just said. Here's what they also wrote in their opinion. By categorically prohibiting citizens from purchasing more than one firearm of any kind in a 30-day period, California is infringing on citizens' exercise of their Second Amendment rights. We are not aware of any circumstances where government may temporarily meter the exercise of constitutional rights in this manner, and we doubt anyone would think government could limit citizens' free speech right to one protest a month, or their right to be free from unreasonable searches and seizures to apply only to one search or one arrest per month. We could go on. If the frequency with which constitutional rights can be exercised could be regulated in this manner without infringement, what would limit government from deciding that a right need only be available every 6 months or once a year or at any other interval it chooses? California had no answer to this concern at oral argument. Powerful arguments there by this three-judge panel knocking out California's law. Now, of course, as a matter of text, we know that the right to acquire firearms is implicated by the text of the Second Amendment, even though, again, the word acquire doesn't appear in the text of the Second Amendment, in the same way that the right to train is protected by the Second Amendment, even though the words train or right to train does not appear in the Second Amendment. These are so-called ancillary rights or concomitant rights that are kind of intertwined necessarily with the textual right to keep and bear arms. So in light of the fact that this restriction, this hindrance, if you will, on the ability to acquire firearms, meaning you only get to buy one a month, is obviously a restriction. And the three-judge panel says that implicates the text. And once it implicates the text, you know what happens. The burden shifts to what? The burden shifts to the government. The burden shifts to the government. And this is not a non-entity. This is not a nothing kind of burden. Just keep in mind in the criminal context that if I am charged with a crime or you're charged with a crime, the government bears the burden to prove us guilty beyond a reasonable doubt that we committed that crime. You and I don't have to do anything. We just have to sit there and listen if we want. We can put up a defense, or we can just sit there and listen, because at the end of the day, it's the government's burden. So too here in the Second Amendment context, once the text of the Second Amendment has been implicated, by the conduct that the Second Amendment rights claimants, in this case people that want to buy multiple guns a month, are implicated or infringed upon, if you will, by the modern-day gun control law, the burden is just to the government, and to do what? To show there's some sort of long-standing historical tradition of firearms regulation that's analogous to this law. And there's simply no such law that restricted the ability of Americans to be able to buy multiple firearms in a given time period, especially since the text talks about the protection of the right of the people to keep their arms, plural. Now, what the state of California tried to do here is they tried to, come up with sort of generic restrictions on the ability to possess firearms. They had some hardware gun bans that he tried to talk about, none of which were analogous, and the court basically dismissed them out of hand. In fact, what the court said, and this is quite interesting, the court actually proffered some very powerful history here to basically show that the argument of California was no good. Because you see, what California tried to do is they tried to say that the issues with arms trafficking or gun trafficking, or the ability to buy multiple guns in a given month, and the consequences, the negative consequences of it, are brand new. This is not something that's occurred before in American history, and therefore this law of one gun a month, which was originally enacted, applied to handguns back in the year of our Lord 1999, then was expanded to all guns, I think in 2023 or 2024. Now it applies to all guns, by the way. But originally in 1999, it only applied in California to, you could only buy one handgun a month. So California tried to say that there's a sort of nuanced reasoning because this is a new dangers and new problems associated with firearms that did not exist at the time of the founding. But the court smacked down this big time. Specifically what the court said, and this is quite interesting, the court brought forth a whole host of laws dealing with restricting the ability to sell firearms to the Indians. They talked about various laws from Virginia and other states, even colonies before the American Revolution, where you were restricted from selling guns and weapons to the Indians, who, of course, were viewed then as foreign nationals, the enemy in many instances, someone that was very dangerous, which is why in the Declaration of Independence, signed in 1776, you have references to the merciless Indian savages being turned loose by King George III on the American colonists. So the Indians were viewed as a pretty bad, dangerous foe, to the point where you could not trade with them with arms, probably in the same way that you're not allowed to sell guns today to the Iranians or to the Russians or to the Chinese as a general matter, because they are essentially viewed as adverse or economic competitors, if not foreign adversaries in all respects. So with that said, the court here says, look, at the time of the founding, the founders were well aware of the dangers posed by illegal arms trafficking, either by selling guns to the Indians or by selling guns to the seceding South right before the Civil War, and the potential problems of them using those guns against the North and so on, and against the country, so on, so on, so on. And basically the court went through all this and said, look, arms trafficking and smuggling has been a danger since before the American Revolution. And the one law or set of laws that were never enacted by the Founding Fathers or anyone at the time of the founding in 1791, when the Second Amendment went into effect, was some sort of restriction on you could only acquire one gun a month or anything like that. Those kinds of restrictions simply did not exist, but the founders were aware of the dangers of gun trafficking, but they did not try to regulate that by restricting the number of guns you could acquire in a given time period. Now, the reason why that's relevant is California was trying to justify its 1 month a gun law by arguing that we don't want people buying multiple guns and then taking those extra guns and selling them in straw purchase situations to people that are not allowed to have guns, or enemies or cartel members or whatever. And again, what the court said here is arms trafficking and illicit firearms is not a new phenomenon. It's been around since before the founding, and in light of that, this is hardly a new problem to consider, and the Founding Fathers never restricted the right of Americans to acquire only so many firearms or so much ammo in a given month. That kind of law simply does not exist in any respect, never mind establishing a long-standing historical tradition of firearms regulation there wasn't even examples of such laws, never mind a historical tradition of regulation, which requires a lot of laws over a lot of period of time, over a lot of territories for it to be really a tradition. Because again, a one-off or a single tree does not make a forest, as the court kind of alluded to here. And again, pointing to one or two laws does not make a tradition. Those are essentially outliers. And again, they didn't even have that in this case in support of California's argument. And the court basically made short work of California's arguments here, ruling in favor of the Second Amendment. So this is great news. Do I think Gavin Newsom and Rob Bonta are going to seek cert from the U.S. Supreme Court? I highly doubt it. I think this is the end of the line. And the 1 month, one gun a month rule in California is probably dead as a doornail for a very long time, if not forever. So anyway, there you have it, folks. Great news out of California. Make sure you follow me on X @4boxes.diner. Don't forget to subscribe to this channel, both on YouTube and on Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.